The Constitution of Colombia, officially known as the Political Constitution of Colombia, is the supreme law of the Republic of Colombia. It was adopted on July 4, 1991, and has been amended several times since then. The Constitution establishes the framework for the organization of the Colombian government, defines the rights and duties of its citizens, and sets out the principles and values upon which the nation is based. Salient features of the Colombian Constitution. 1. Democratic system. The Colombian Constitution establishes Colombia as a democratic republic. It recognizes the sovereignty of the people and the separation of powers among the executive, legislative, and judicial branches of government. 2. Fundamental rights. The Constitution enshrines a comprehensive set of fundamental rights and liberties, including the right to life, liberty, equality, privacy, freedom of expression, assembly, and association. These rights are protected and can only be limited in specific circumstances defined by law. 3. Social state of law. The Constitution establishes Colombia as a social state of law, emphasizing the responsibility of the state to promote social justice, provide basic social services, and protect vulnerable populations. It aims to reduce social inequality and ensure the welfare of its citizens. 4. Presidential system. Colombia follows a presidential system of government. The president is the head of state and government and is elected by popular vote for a 4-year term. The president appoints ministers and heads of government agencies. 5. Separation of powers. The Constitution provides for the separation of powers among the executive, legislative, and judicial branches. Each branch has its specific functions and powers, ensuring checks and balances. 6. Bicameral Legislature. The Colombian Congress is a bicameral body consisting of the Senate and the House of Representatives. The Congress is responsible for making laws, approving the national budget, and exercising legislative oversight. 7. Regional autonomy. The Constitution recognizes the autonomy of Colombia's departments, administrative regions, and municipalities, allowing them to have their own local governments and make decisions on matters that affect their territories. 8. Judicial Independence. The Constitution guarantees the independence of the judiciary. The judicial branch is responsible for interpreting and applying the law, protecting individual rights, and resolving disputes. Colombia has a hierarchical court system, with the Constitutional Court as the highest court for constitutional matters. 9. Peace process. The Constitution acknowledges the need for peace and reconciliation. It provides a legal framework for peace negotiations and the integration of former armed groups into civil society. It also establishes mechanisms for truth, justice, and reparations for victims of the armed conflict. 10. Constitutional reform. The Constitution allows for its own reform through a rigorous process. Amendments can be proposed by Congress, the President, or through popular initiative, but significant changes require broad consensus and approval by the Constitutional Court. These are some of the salient features of the Colombian Constitution. It is designed to safeguard the rights and liberties of Colombian citizens, promote social justice, and establish a democratic system of government. Thanks for watching this video, and also subscribe Advocate Buzzard Shaw channel.